Vale, puedo checar ahora. I guess on there whenever you want.
Mr. Knudsen, can you hear us?
Good morning, Judge. Or good afternoon. Can we find out where our client's at?
He is not gonna connect from his office.
Oh, okay, he's
He's
connecting.
connecting. I told him we're early birds.
Mr. Dodson, how many witnesses are you gonna have?
Okay, you can lower down all your volume here. We don't need volume.
There's a little echo.
How many witnesses are you gonna have, Mr. Dodson?
Probably 3,
Thank you.
including Mr. Tames's clients.
How many witnesses are you gonna have, Mr. Thomas?
My 2 clients.
Sure. Looks like we have a total of 5, just to give you all a heads up.
As far as volume goes, are we good?
That is very loud. What, the volume, Judge, can you?
I can hear everybody fine.
No, Mr. Knudsen, can you hear us? Mr. Knudsen, can you hear us?
Yes, I can.
Well, I have a loud voice.
Okay.
We can hear you very loud. Were you talking? Mr. Knudsen?
Mr. Dodson,
Yeah.
can you okay?
Yeah, I can hear you all fine.
Okay, perfect.
Good, so.
Let me just make sure my client gets on. I'm not sure if he's on yet.
Okay.
He's trying to connect right now.
Before we get on the record, just to let you all know what I'm gonna do, I'm gonna give each side about 3 or 4 minutes to tell me about their case.
Okay.
And we'll put.
And I did email, Your Honor, did you, Mr. Tames, 2 documents to the court. I'm not sure if they provided that to you.
Yes, I
And
have.
then I just got to the office. I had another hearing with Judge Lopez, and I got a big stack of documents from Mr. Tames.
And I've had a chance to review the exhibits from both sides already and the pleadings.
Okay.
No, I won't. No, I haven't called the case.
He's connected. He should be in the waiting room.
Okay. No, I mean, I need to talk to Silverio about this. It's like delay.
Because his client, his secretary called me and said, can you have Mr. Nelson sign?
No,
So I'm like, maybe he has an agreement, I don't know, but.
I might agree to this one, but not for the new pretrial guideline order, October, November, December, January, maybe February. I need to see what they have in February,
I'll check the dates.
and then I'll look at that.
And you have opens? Opens.
Your Honor, I need to see where my client's at. He must be having trouble trying to connect, and he needs to hear everything. So,
He speaks English.
excuse me?
Does he speak English?
Yes, he does. And I think so do Mr. Tames's clients.
We don't need an interpreter. though.
No, Judge.
Is Mr. Tames there in the courtroom?
Yes,
You should see him on your screen. You don't see him on.
Right, but is he there in the same courtroom as Your Honor?
Yes.
Okay, well, I mean, I wish I would know that. Are his clients there in the courtroom?
Yes.
You know, maybe, I think it may be more prudent that I go over there with my client, to have a fair, not that we're not going to get a fair deal, but just have equal footing,
Judge,
Where's Pettis?
Mr.
Vanessa?
This is his petition. He
What?
reached out, asking that my clients be present here today. we're here today. He had equal opportunity to be here today. So proceeding in his office.
The notice was via Zoom, Mr. Tames. Did you not understand that? Or, I mean, was it via Zoom, Your Honor? I'd ask you to take judicial notice. Was it in person or was it via Zoom?
I don't have, I'm not,
If we can have the clerk let us know what it is for the record. Because I don't appreciate Mr. Tames saying that like somehow that, oh, we were ordered to be there in person. If we were, then I apologize for my error and I'll be on my way. And I got my jacket here. If it wasn't, then,
Judge,
and I'm having a hard time hearing Mr. Tames, especially, I guess, there in the courtroom. He's not very clear.
Mr. Knotson, can you hear me?
That's better. Better.
I have a copy of the precept, Judge, that was issued to my clients. And it says that the hearing is set for the 12th of October at 3 p.m. in the 341st District Court. And so that's why we're here. The command or the precept is for them to be present at the 341st. There's nothing in the rules that prevent us from not being present. As a matter of fact, I asked the court coordinator if I could be present. I was told that I could. I think at this point,
Okay.
an election by council, whether they want to be present or not, I think the due process rights are preserved by allowing council to appear remotely or appear in person. So
I agree, Mr. Knotson.
Yeah, I have no problem with that, but I just want to advise my client. I think, we can give an opening statement right now, as you said, 4 minutes each, and then I can ask my client how long it'll take for him to be there, and then we'll head over there. Mr. Pettis, can you hear us?
Yes, sir, I can.
If they're there in person, so, I mean, I would feel more comfortable. The judge is very fair, but I would just be, since they're in the courtroom, I would prefer that we be in the courtroom. How long would it take you to get downtown?
About 30 minutes.
That long?
We're gonna lose too much time.
Yeah.
It's already
3.
a little bit past 3. So if you want to make an oral motion on the record, I haven't called the case yet, Mr. Knotson, I'll allow you to do that, but time is of the essence, and you were the one that set this hearing. It would have been incumbent upon you to find out whether people were going to be allowed to be live.
Yeah.
Okay. Yeah,
Judge, I did call his office like about 2:35 to let him know.
Whose office?
Your office, Mr.
that's Sonia, the administrator for the court. Let me call the case. Good afternoon, Mr. Good to see you again. But it might be better, Mr. Thomas. Go ahead and stay there for right now for your opening.
Yeah, because I think I get feedback if I put my microphone on the laptop, Judge.
The court calls 2021 CVI 1809D3 James Pettis Vitamosa Logistics versus Carmen Serra and Jaime Serra. Appearance of the attorneys for the record, please.
Marcel Nasson here on behalf of James Pettis.
Mr. Thomas.
Judge Francisco Tamés for the defendants, Jaime Cerda and Carmen Cerda.
Is the plaintiff ready to proceed?
Your Honor, subject to our oral request to be allowed after we make our opening statement to be there in person. I really don't think it should take more than about an hour and 15 minutes to be done with the presentation.
We have 5 witnesses. Well, at any rate, your motion to delay the hearing is denied. So, Mr. Knotson, you may proceed. Can you tell the court in about 3 or 4 minutes what this case is about?
Yes, Your Honor. This is a case where my client, James Pettis, relied on his cousin, Jaime Cerda, and his wife, Carmen Cerda, where they set up a company, Litmosa Logistics LLC. where my client was going to be 50% owner, and Mr. Cerda and Carmen Cerda were going to be 50% together. And, basically my client relied on their representations. This was going to be, a transportation logistics company. My client put in approximately $141,425 in expenses that he paid for the business to be operational. Without my client contributing, there would be no business. Zero, zilch, none. This is a fraud, clear and simple. Basically, my client he also put in $100,000 for 2 employees that he paid for out of his funds that did work for Limosa. So that's out of his pocket, $245,708.79 that approximately my client has paid for the business. Basically, they agreed that from the profits, he was going to be paid back first, and then any profits split 50-50. There's going to be no salaries to either one. Basically, to my client's surprise, there were various deposits like cash withdrawals, 500, 300, 400, a check on 6/22/2020 for $5,000, another check for $3,200. That there's been no accounting for that. Another check for $7,000, check for $8,000, and personal items, Sherwin-Williams, where my client's cousin was redoing his home, and that has nothing to do, Sherwin-Williams, with the transportation business. Harbor Freight, $268, Lowe's, I guess, for materials for the home construction, check $1,500, $1,800, $1,500, $1,000, $3,000, $1,250. Several checks here, where that there's Zarsky lumber, that he's using for his home that, he's taking out from the company in violation of their agreement. My client gave him a handout, Judge, to help him up, to help him get on his feet, and he got stabbed in the back by his own family. So basically, he violated this agreement. We're claiming a constructive trust and a temporary injunction. Clearly, my client, on the Secretary of State documents, they only included Jaime Cerda and Carmen Cerda. They didn't include him in violation of their agreement. So this is further evidence of the fraud. Defendants Exhibit number 1. They would not have been able to operate without my client's funds.
One of the things I think you need to clarify, when I read your petition, paragraph number 10 indicates there was a loan or investment loan of $141,425.60. There was really no explanation as to how and when that happened. And I reviewed, there were the verification, but there were no attachments. So I'm assuming that the agreement you're speaking of was oral and not written.
Yeah, well, there's the exhibit that I sent, Your Honor, that you said you reviewed. There's a second exhibit. It says various attachments. There's a 1-page summary. It says January expenses, Uber transport, where it shows all the different funds that were expended, for a total of 141,000 or 241,425.60. There was 2 employees at 50,000 per year that my client will get into and Mr. Pettis, make sure you have those exhibits there in front of you. When I ask you about those, which is 241,000, where, basically there was, various auto parts, Laredo Trailer Supply, Rotex trucks, where he's purchasing stuff. And that's where the money comes from. This was the operational funds to get the business operational. And so that's where that comes from. And it's,
My understanding was that the corporation was established in 2018, though.
yes.
Okay. Let me hear from Mr. Gomez. Mr. Gomez.
Oh,
Judge, we have a-
How do I do that?
Hilda's here to help you see if I can figure it out. Because I'm inside and I could barely hear him.
Can you hear me, or who you having a hard time hearing?
Oh, I can hear you perfectly, Mr. Knudsen.
Okay.
Well, no, would it have to be from the mic, right?
oh, do you want me to move that over
Why
there?
don't we move the mic?
Oh.
I can move up,
podium
yes.
closer.
Right there's fine.
Put it on a book or something,
Yeah.
so it's on the book. There is he's-
Well,
Can you hear me? Can everyone hear me better now?
Can you hear Mr. Knudsen?
And more importantly, Clayton,
yeah,
Mr. Clayton?
Mr. Clayton, can you hear me okay?
Yes, I can now, but as before it was.
yeah.
Okay.
That's too strong. You need to put it back a little bit.
Go ahead, Mr. Gomez.
Thank you, Your Honor. On behalf of my clients, Jaime Settle and Carmen Settle, Judge, when I looked at the petition, obviously we're here on a temporary injunction hearing. The question is whether or not the plaintiff has a right to recover. And what plaintiff did, and I heard Mr. Knudsen just say that he represented Mr. Perez and not what he calls Mosa Logistics, is that he's acting in the capacity or the purported capacity as an owner of Mosa and has injected himself to get a restraining order preventing my clients from acting on behalf of Mosa. So when we look at ownership of a company, there's two ways, right? There's the documentation, all the documents that would show an incident of ownership that any owner would undertake when creating a company. We talked about the filing of the company. There's other documents there, for example, permits with state and federal authorities. There's bank accounts. There's contract with third parties. All the documents that are incident of ownership all indicate that Jaime and Carmen Cerda are the owners. So then we jump into this idea that there's an oral agreement. And the law is very particular about what it requires when we're talking about oral contracts. The scrutiny is heightened because when we don't have a document in writing, then we have to go into elements of what those characteristics are to find out and hold that two persons are indeed in a general partnership. And I'll discuss those in closing, Judge, but for purposes of the introduction, it's important to note that when we're talking about an oral contract, we have to have definitive terms where the parties clearly and unequivocally understand the terms of that agreement. And any diversion from that certainty, it's basic contract 101. There isn't a meeting of the minds and we don't have an agreement. And as the evidence will show, Judge, is not only can we show the documentation where we have established that my clients are the only owners and have always acted as the only owners. But we also have the plaintiff's own admissions, where he has accepted that Lita Mosa is my client's own company. I think for purposes of the TI hearing, that's where we're
We
at.
don't agree with that.
Well, Mr. Knudsen,
For the record,
it's just an argument.
yeah, I understand.
And whether or not Lita Mosa by my clients was going to be used with the plaintiff to generate business, that's a different story. But that doesn't make plaintiff an owner of Lita Mosa. And we recognize that there was help that he was providing Lita Mosa in getting contracts, but that's very different from now coming in and saying, I'm an owner of Lita Mosa. And so, and we'll discuss that, Judge. I don't think that there's any contention on our part, but when we asked the plaintiff for evidence of expenses he was alleging that he was paying on behalf of Lita Mosa, he didn't provide any. And as a matter of fact, as the evidence will show, one of the exhibits that he relies on, that's actually a reconciliation report from Lita Mosa's bank account, where the only authorized signatures are my clients. And so for purposes of today, just for purposes of whether or not the court is going to enjoin my clients from acting in a free enterprise, Mr. Knudsen's burden is heavy, because not only does he have to show that all the elements of an Orgel contract, but then he has to show that that gives him the right to recover. And so with that, Judge, we're ready to proceed.
Mr. Knudsen, your first witness?
Mr. James Cerda. Or let me see, I'm sorry, Jaime Cerda.
Should we have him stand in front of that mic? That way
Yeah. Vanessa, do we have all those things scanned? Okay.
Right, am I fine here? You want me closer?
right there. No, you can come closer. And I'm going to ask you to raise your right hand to be sworn in by the clerk.
It's raised.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank
you. Mr. State your name for the record.
Jaime Alfonso Cerda.
Jaime what?
Alfonso Cerda.
Okay. And what's your date of birth?
083071.
Okay. So you're 50 years old?
Yes.
And are you related to the plaintiff, James Pettis?
Yes, I am.
And what's your relation?
I believe we're second cousins.
All right. And do you believe that you should be honest with your family?
I do believe so, yes.
And with anybody for that matter, correct?
That's correct, yes.
And as your attorney said, there was help from the plaintiff in generating business. Is that correct?
In what way? I don't understand the question.
Well, did you hear your attorney tell the judge, Your Honor, there was help from the plaintiff in generating business for Mosa? Was that an accurate statement to the court or not?
Yes, it was.
Your attorney said that.
Yes, it was.
Okay. And explain to the judge what help did Mr. James Pettis give to Mosa?
Well, the help that he was supposed to give is to get our trucks up and running. That was
okay. No, sir. The question is,
Objection asked.
what help did my client provide? Not what he was supposed to provide. Explain to the court what help did he provide?
Objection asked and answered, Judge.
Do you understand the question, sir?
Well, I think Mr. Knudsen's correct. I'm going to overrule him. I think he answered he was supposed to get the trucks up and running. So just, if you can clarify your answer, Mr.
Yes.
Sure. So Mr. Pettis was supposed to, like I said, get the trucks up and running, which included making them profitable, get them drivers, get them loads to run, whatever that entailed. which included, um, you know, like I said, getting loads for the trucks, making sure that they were running correctly and safely.
Okay. And what help did he provide? So he didn't put in a penny to the company. Is that what you're saying? He never put in one single penny.
I'm gonna object as to.
Ask the
as-
question, Mr. Knudsen.
Yes.
That's, you're being argumentative right now. Ask a
The
question.
what?
You're being argumentative.
Okay.
Ask a question.
All right. Sir, so you did not make, you understand, you took an oath. You swore under God to tell the truth, the whole truth, and nothing but the truth, correct?
Judge, I'm gonna-
Knudsen, yes, I asked the question, Mr. Knudsen.
Okay. Sir, you understand your oath?
Yes, I do understand my oath.
And you understand that if you're not completely truthful, you could go to jail, correct?
Yes, I understand that.
All right. And have you ever testified before?
No,
Do you have a criminal record?
no, I do
Judge,
not.
objection relevance.
It is completely irrelevant, Judge.
I
I'll
understand.
move on.
Let's get to the point.
Yeah. So, sir, did my client provide monies for Limosa LLC?
Objection vague, Judge.
No, I think that's a very clear question. Well, you can answer.
Okay.
Just a second.
Your client did not provide money to form Litamosa Logistics.
Did you understand my question, sir? Objection non-responsive, Judge.
Oh.
That was my question.
Hold on, let's not get on. Follow up, clarify, Mr. Knudsen.
Sir, you know, I'm not trying to be argumentative, sir, but if you can listen to my question, if I ask your name, I'm not asking for your date of birth, where you were born,
Knudsen,
just your name. So if you can answer
Mr.
what
Knudsen,
I'm asking.
I'll admonish the witness, just clarify your point. Ask the question.
Okay. All right, if you can admonish him just to listen, sir, if you can listen to my question, if you don't understand it, let me know. But if you can only answer what I'm asking, not what you think is going to be helpful to your case, you understand that, sir?
He understands now. Ask your question.
Okay. Sir, my question is, did my client ever provide money to Limosa LLC? It's a very simple question.
I'm gonna object. I'm gonna
No,
object.
hold on.
Yeah.
I'm gonna overrule. You can answer that question.
Your client provided money to pay expenses for the trucks that were operating.
And if he wasn't an owner, why would he do that?
That's what he presented to us, to my wife and I.
But why would he do that if he's not an owner? Does that make any sense, sir?
Hey, Mr. Knudsen, that calls for speculation. Sustain the objection. Ask another question.
Okay. All right. Do you know why he would do that? Did he explain to you why he was doing that?
He was doing that to make the trucks operate and become profitable.
Okay. And at some point, I mean, did you have an agreement with your cousin, James Fettis, for him to put that money in?
The only agreement we had was
It's a yes or no, sir. It's a yes or no.
Judge, he's answering the question.
Let him answer the question, Mr. Knudsen.
The only agreement we had was to get my 2 trucks and his 2 trucks operating.
Okay. And there's no further agreement to
No.
get them operating? What happens with the money? What happens with the profits? You
He
know,
was-
so you're saying that's the only agreement. So are you telling the whole truth there, sir?
Yes, I am.
Okay.
The agreement was that he was to take profits on his 2 trucks and I was to take profits on my 2 trucks.
Okay. And how long you been in business? I mean, how long have you been a businessman?
Objection
I don't
vague.
understand. What is,
How long have you been a businessman?
In what-
3 years or 20 years or how long?
It's a general question. If you can answer it, if you know.
I've worked for FedEx for all my life, for 20 years. And since then, I guess I consider myself a businessman.
And what did you do for FedEx?
I'm a regional manager.
Okay. So you know about business and transportation, correct?
Correct.
Okay, how much money did you and your wife put into the business?
I don't know the exact amount. I mean,
Okay,
over,
Answer if you know.
I mean, at least over $50,000-$60,000.
okay. All right. And so there was 4 trucks for Limosa, is that correct?
2 trucks belong to James Perez and 2 trucks belong to us, and they were under my wife's name.
Which the 2 trucks under that you and your wife put in?
Yes, that we purchased.
With your own funds or with your cousin's funds?
No, they were purchased with funds that I borrowed from my mother.
Okay. How much did you borrow from your mother?
That the exact amount, I believe it was $33,000.
Okay. And was there a mortgage or a payment, monthly payment on those 2 trucks, or were they paid in full with 33,000?
They were paid in full.
Okay. So they were used trucks, right?
Correct.
Okay. And are you aware that James Bettis has put in approximately 141,000?
No, I was not.
Okay. Was he supposed to get reimbursed all those expenses?
I tried to sit and review that with James Perez, but he was never available.
Okay. So you were aware of the 141,000 and you just wanted to go for the verified, take them back.
I wasn't aware of that amount. No, I was aware of expenses that James Perez paid.
So you're telling the court under oath that he never told you the amount nor provided any documentation as to how much it was. Is that correct?
That's correct. Yes.
Okay. Did you get, hold on, Vanessa, do we have that demand letter that we sent them? Did you get a demand letter from my office before we filed this lawsuit, sir?
I received an email. Is that what you're speaking of?
Yeah. Did you get a correspondence from my office saying, hey, here's the amount due, please call my office so we can sit down and go over this?
Yes, I did receive that.
Can you tell the judge how many times you called me? 0, correct?
Objection, relevance, Judge.
Well,
This is
It's
not
completely
just
relevant, Judge.
Judge, this doesn't go to ownership, it goes to a demand.
He's saying he wanted to sit down to go over this, and if we can scan it, pull it up so the judge can see it.
Court now knows that he did not call you, so let's move on.
Okay. Did you ever call me back? That was on May 13th of 2021, correct?
I don't know the exact date. No.
Almost 5 months ago, sir. We're October 12th. That was over 180 days ago. And you never called me once. You never wrote me a letter once, did you?
Objection, relevance, Judge.
He can answer. I'm gonna overrule. That's fine.
No, I did not.
All right. Tell me when it's ready to pull up. Thank you, Judge. Can you look at that, sir? I'll mark this as Exhibit A and I'll submit it to either the court reporter or the court's secretary later. Is this a true and correct copy of the letter? If we can go down a little bit? Is that your correct email, sir?
That is, yes, correct.
And is that your wife's correct email?
Yes, it is.
And tell the judge the date of that letter. Go up, Vanessa.
May 13, 2021.
Okay. And basically I said, please be advised that I represent James Pettis with regard to his 50% interest in the business, period. Did you ever say, Mr. Knotson, excuse my language, what the hell are you talking about? He doesn't own anything in this business. Did you ever do that?
I think we covered this already, Mr. Knotson. We already know.
Excuse me?
I think we covered this. He did not respond.
No. Now I'm talking about, he never responded to me, but here, when we're talking about, I advised him, did you ever send me anything to say, hey, your client doesn't own anything in this business?
No, I did not.
Did you? Okay. Did you ever reach out to a lawyer before you got sued to say, hey, everything in this letter is incorrect. I want you to respond right away. Did you ever do that?
Yes, I did.
Okay. Who did you contact?
I contacted Mr. Tames.
Back when?
Objection, relevance, Judge. We're getting into attorney-client
No,
information.
I want to know if it was,
Judge, the
I'm
purpose,
not asking what they discussed.
the purpose of today's hearing is whether or not his client is an owner of Limosa.
I understand
Or
that,
Limosa as it's legally established. And so whether or not he went to a lawyer or not is not relevant. I think we need to get to the point of whether or not there's an agreement.
Yeah.
And this doesn't help.
Your Honor, I think it's rough.
A second, we're not gonna cover too much on this point. I mean, I'm assuming you're gonna offer this into evidence?
Yeah, and again, objection.
Yeah.
Judge. Yep. Admitted it. He's already asking questions on it. So.
Your Honor, I'd ask that Exhibit A be admitted for purposes of this hearing only.
Any objections?
Just relevance, Judge.
Okay, I'm gonna admit it, Mr. Knotson.
Thank you, Judge. Now, sir, when's the first time you contacted Mr. Tames?
I don't know the exact date. Sorry. I don't.
What month?
The end of May, possibly. I mean, that's my best guess.
And so you think it's appropriate no one ever responds for 4 months at the end of May,
Mr.
June,
Knotson,
July, August, September?
you're being argumentative again. Ask a question.
Okay. And don't you think if there's a misunderstanding that should be cleared up sooner rather than later, sir?
Of course, I did try to reach out to James Perez and he was not available for me. I did try to resolve this.
Okay. I said, please advise when we can set up a meeting to discuss. Did you
Previous to
provide
your-
me any date?
Previous to your
Did you
letter.
ever provide dates?
I'm sorry, what was the question?
Did you ever provide me any dates that you could meet?
No, I did not.
Okay, so we never refused to meet with you on any occasion that you were available, correct?
I never asked.
Okay. All right, now, do you agree that you and your wife should abide by any agreements that you made with James Pettis?
Objection vague. What agreements are we talking about, Judge?
I'm gonna sustain that. Can you clarify?
Okay. Yeah, let me clarify. If you made an agreement with James Pettis, and this is an if you and James Pettis agreed, look, you're gonna help us out and you're gonna be 50% owner and me and my wife are gonna be 50% owner. Thank you very much, primo cousin. I really appreciate it. You should abide by that agreement, correct? If that's if, or do you not abide by agreements that you enter into?
Judge, again, it's kind of like a run-on question. I'm not sure what the question is.
Yeah, and it's speculative, Mr. Knudsen.
Sir, are you the type of man that abides by agreements that you make?
I'll allow that. Go ahead.
Yes, I am.
Okay, so if you and James Fedez and your wife agreed he was gonna be 50% owner and you and your wife are gonna be 50% owner, you should abide by that agreement, correct?
That was not the agreement.
Okay, if it was, should you abide by it, sir?
It
Okay.
seems facts, not an evidence, Judge.
I'm going to sustain
It-
on Mr. Knudsen.
Okay. Do you have anything that shows, other than you all being 50% owner, what the agreement was? Do you have anything to show that, sir, to the court?
I'm sorry, what's the question?
Do you have anything in writing to show that other than the agreement my client swore to, a sworn verification that he was 50%, you and your wife were 50%? Do you have anything in writing that shows otherwise? Yes or no?
I have in writing the formation of the corporation Lita Mosa that shows my wife and I, the owners.
Okay. But nothing in writing with Mr. Bettis signed
No,
that says what the agreement is that you're alleging to the court. Is that correct?
well, you're alleging to the court.
Yeah.
I'm not alleging anything. You're alleging
Okay.
agreement.
All right. Well, you told the judge is there any other agreement that you and James Fettis had and your wife, other than what you've told the judge already?
No,
What was the answer?
No,
no,
Okay, thank you, Your Honor. And now your attorney advised the court that the only authorized signatures for Lita Mosa LLC is you and your wife. Is that completely true?
that is correct.
Okay, so you're telling the judge that James Fettis was never an authorized signer on Lita Mosa, correct?
That is correct, yes.
And Judge, for the record, it's Lita Mosa,
with an A. I
Yes,
saw
yes.
that. Okay, no worries.
just so the record's clear.
Oh, Lita Mosa, okay,
After the T, yes.
okay. Hold on a second. All right. So when my client said, hey, I'm owed money back, he never gave you a time. That's what you're telling the judge.
That's correct, yes.
Okay, you never said, what the hell are you talking about? I don't know you, Jack. Did you ever tell him that?
No, I did tell him that. I tried to look for him. I even went by his office. He was not available.
All right. Now, if I told the judge, hey, Mr. James Cerda owes me $50,000, what would you say?
Objection, vague, Judge, I don't
Yeah.
follow.
I'm trying to make a point here, Judge.
I know, but your hypotheticals aren't really getting there, Mr. Knudsen. Just
Well, I think it will. What would you say, Mr. Cerda?
ask the question again.
If I said, Jaime Cerda, I want to sit down and meet with you because you owe me $50,000, what would you say?
I'd say no.
Why not? Why?
I don't owe you $50,000. I don't know Marcel Knudsen $50,000.
Okay. So you do admit that you owe James Fettis money. You just wanted to see how much, correct?
I never didn't say that I did not owe him money. I tried to track him down for receipts. He never provided receipts.
Okay. All right. And so if he provides receipts, you're willing to pay him back?
I'm willing to review and see if they pertain to the trucks that he was running.
Who paid the insurance on all the trucks?
Objection, which trucks?
All 4 trucks. Was it James Pettis or was it you? Or you paid half and he paid half?
We paid for our 2 and he paid for his 2.
And you have proof of that?
I don't recall. I may have the check, yes.
Okay. Okay. All right. So, okay. So, and where did all the revenue for my client's 2 trucks go to? Lita Mosa?
No, while he was managing the revenue for those 2 trucks, for those 4 trucks.
My question, sir, was, and I don't mean to be repetitive here, where did the money go from the revenue on the 4 trucks?
Yes.
Your personal bank account, his personal bank account, or Lita Mosa bank account?
There you go. That's a valid question.
I never saw any revenue for the 2 trucks that we owned while James Perez was managing them.
Okay, so did you even, so you telling the court you have no idea where that money went? Under oath, that's what you're telling them.
That's what I'm telling you, yes.
Okay. When did he manage the company?
He did not manage Lita Mosa. He managed the trucks.
Okay, so you never said, James, where's the doggone money? Where is it? Show me. You never told him that?
I did several times. And he would just send me to his office to sit with his employee to review numbers. I didn't even know what they were.
Okay, so you worked for FedEx for 20 years as a manager, supervisor, regional manager, and you're saying you don't know what those numbers are?
Objection, ask to answer.
You really expect the judge to believe that?
Objection, argument.
Ask a question, Mr. Knudsen.
So you're telling the judge under oath that as a regional manager for 20 years, you had no idea what those numbers were?
I'm saying I never saw any receipts or documentation to back up the numbers. That's what I mean.
Okay, so you did understand the numbers, you just didn't see proof of it.
Correct.
And do you have any emails saying, hey, I need proof of primo, cousin, I need proof of these revenues and expenses?
Yeah, there's text, probably there's text over a number of years where I'm trying to find out if they're working or not and trying to get answers from them.
Okay. So, look, can you tell the judge why in the world would you have not responded? You said you wanted to meet with James Pettis, correct?
That
To
was
go over numbers, correct?
that was previous to the letter that I received from you.
Okay, so explain to the judge why in the world did you not sit down for the last 6 months to go over this stuff and come to an agreement?
Objection, relevance, Judge.
I'm going to sustain that. Ask another question, Mr. Knudsen.
Okay, well, you know, I mean, I think it's relevant why he wouldn't do that, Judge.
Well, the court already understands that he did not reach out to you, Mr. Knudsen.
Okay. All right. In the last 6 months, have any funds been moved from Lita Mosa?
Objection vague, Judge.
I don't understand.
What funds, what movements?
Yeah, it's kind of overly broad there, Mr. Knudsen.
Okay, other than the ordinary course of business, were any funds withdrawn from Lita Mosa in the last 6 months?
Again, objection vague, Judge. Can you define ordinary?
It's clearly relevant, Judge. If they're, they went and raided the company for the last 6 months, that's completely relevant whether we're entitled to equity and an injunction.
Well, hold on a second. Yeah. But you got to ask your questions, not assuming that there is any equity right now, Mr. Knudsen.
That what?
You said you need to ask questions assuming there is no equity right now. Narrow down your questions. It is kind of.
Right. And I'm trying to find out. From when you received this letter on May 13th of 2021, did you or your wife take out any funds from Lita Mosa, like cash withdrawals that were not for normal operator expenses, diesel expenses, mechanical expenses, anything other than that? Did you all take out any money in the last 6 months?
Objection relevance, Judge.
I'm going to allow it. Go ahead and answer, Mr. Second.
For normal operations, no.
I don't understand your answer.
I mean, to keep the business operating, no.
So other than business operating, there were no funds taken out. Is that an accurate statement?
And again, Judge, the problem with this line of questioning is that we get into accounting terms. And we're talking about operational expenses, and I don't want this to be prejudicial to my clients later on if Mr. Knudsen in discovery or in litigation or a trial starts raising definitions of what operational expenses means, what ordinary course and scope.
Let me, Judge.
So I think we can agree that it's.
Speaking objection.
Yeah, hold on a second. And the court understands we're talking in general terms here. I mean, I have printouts, but again, nothing to back up other than what was provided.
Okay.
I understand your concern, Mr. Dumbass, but I don't see how anybody's going to tie down these questions. So that's why, if that's the way he wants to proceed.
Yes, sir.
I'm going to give Mr. Knudsen a little bit of latitude here.
Yes, sir.
And he is an adverse witness.
Thank you, Judge. So, so other than normal operating expenses, which is, what would you consider normal operating expenses? Number one, diesel, correct?
Correct.
Operator pay, correct?
I'm sorry, what was that?
Operator pay,
Correct.
insurance on the trucks,
Correct.
maintenance on the trucks, oil changes, tire changes, things of that nature.
That's correct.
You never dispersed any monies to James Pettis, correct?
I never dispersed monies to James Pettis, no.
Okay. And you told the judge, other than operating expenses, you never dispersed funds to you or your wife, correct?
I'm sorry, please repeat the question.
Can we have the court reporter read it back, Judge?
Mr. Clayton?
Within operating expenses, you never dispersed the funds to you or your wife?
No funds were dispersed to James Pettis, and then I asked you, no funds were dispersed to you or your wife, correct?
Not correct. No.
Okay, please tell us what is correct.
But there are funds as regular pay for my wife.
How much was that?
I don't know the exact amount.
Well, what is the approximate amount?
I don't know. I can't come up with an approximate right now. I don't know.
Well, who writes those checks?
My wife.
So you don't know what your wife makes?
Mr. Knudsen.
Does she get paid weekly, monthly?
Mr. Knudsen, he just answered your question. He does not know. Move on.
So your wife would know that answer, correct?
I don't know. I don't know.
But she's the one that writes the checks, correct? Is that a correct?
Yes, she's the one who writes the checks.
Okay. and there's no funds for cash that's dispersed or things of that nature.
Objection, relevance, Judge. Again, we're getting into the minutia of running this company, which has nothing to do with ownership.
And Mr. Knotson, I'm going to allow this last question, but I think Mr. Tamez has a point. You're trying to establish ownership. And right now, the only thing I have in front of me indicates that they are the owners. So you may want to get to the point.
Okay. All right. Now, if the agreement with you and your cousin was that he was going to be 50% and you and your wife were going to be 50%, you should have set up the company that way, correct?
That was not the agreement.
Objection, non-responsive, Judge. Can you advise them to listen to the question and answer it?
The answer you got, Mr. Knotson. I understood your question and the answer. Next question.
Okay, sir. If Mr. Pettis set up the company and the agreement was 50% him and 50% you and your wife, if he set it up 100% in his name, do you think that would be appropriate?
Depending on the agreement.
I just told you what the agreement was.
Can you repeat the question?
Okay. If, you know, and Your Honor, can he face us rather than his wife? Or
Where's the camera? I'm sorry. Because
He
I'm
was
looking at
your
it.
face,
Yeah.
Mr. Knotson.
Okay,
yeah.
On the big
Okay.
screen.
I know
Thank you.
it's difficult.
that's
Well, the other
fine.
camera right there on your right.
This one right here? Okay.
Yes.
So, sir, if the agreement with Mr. Pettis was he was 50% and you and your wife was 50%, and he set up the company with Secretary of State, you would expect for him to set it up. Do you think it would be appropriate if he set it up 100% for himself? Do you think that would be appropriate if the agreement was it was 50 him and 50 you and your wife? Yes or no? Obviously no, correct?
Objection, Judge.
Let him answer, Mr. Knotson. But Mr. Knotson, you're asking the witness to answer hypothetical questions that have no bearing right now on what the court has to determine.
And Judge, I'm just, it has a complete bearing because the next question is, my client is swearing under penalties of perjury. That's what the agreement was. And they screwed him and stabbed him in the back and
Okay.
set it up different than what they agreed
Got
to.
that from your opening argument, Mr. Knotson. I don't need to rehear that. Do you have any?
And
further
Judge, I'm trying to lay the predicate for questions for my client.
I understand that, but you keep asking him questions about his moral compass.
No.
And
Do you think it would, and that goes to the equitable grounds, Judge, you know, if that's what the agreement was, should my client set it up 100% in his name? And I think the answer is going to be no, unless he thinks that's okay. Then that's relevant to know, you know what? He thinks that that's okay to do that. So then he's doing it here.
We're arguing with the court. Ask a question.
Okay. Mr. Cerda,
Mhm.
if the agreement was that my client was 50% owner, you and your wife was 50% owner, would it be appropriate for my client to set up the company 100% in his name?
Object. It seems facts, not evidence, Judge, and it calls for speculation.
Sustained. Another question, Mr. Knotson.
Okay. Your Honor, can I have an offer of proof?
What grounds, Judge?
I'd like him to answer that question for my bill.
Can't force him to answer a question on a bill. He can only preserve the question, Judge.
Mm-mm.
The objection was sustained. You can take that up if you want on appeal, Mr. Knotson.
Okay.
Request is denied.
All right, sir. If the agreement in this case,
Mr. Knotson.
for my client, you understand my client? Oh, I'm asking a different question. If the agreement in this case was that you and your wife told James Pettis he was 50% owner, gonna be 50% owner of the business, you should have set it up that way, if that's what the agreement was, correct?
I think that's what you've been asking, Mr. Judge.
It has, but you can answer it again.
Okay, and ask your question again, please.
Your Honor, if we can just have a running objection for Mr. Tames, because the question, sir, is my client has sworn
Mr.
that,
Johnson, we're back with the question whether or not there was an agreement, whether,
yes,
re-ask it.
okay. I'll try to re-ask it. If not, I'll have the court reporter read it back.
No, Mr. Knudsen, because it was asked and answered. I'm going to go ahead and sustain the objection.
Okay. Well, Your Honor, I would like to ask it, because I just want to be clear. If the agreement was that my client was 50% owner and you and your wife were 50% owner, the company should have been set up that way, correct?
Mr. Knudsen, the court has ruled on that. That has been answered. The
Okay.
witness already stated several times there was no agreement,
The what was the answer?
that there was no agreement.
Okay,
I don't know how many ways he has to tell you. We need to move on.
okay. Okay, sir, was there an accident involving one of the businesses? I mean, one of the trucks that belonged to my client?
From what I can recall, yes.
And didn't the insurance company pay approximately $12,000?
Objection calls for speculation, Judge.
He knows.
If he knows, he can answer.
From what I can recall, yes.
And you haven't given that money to my client, have you?
Again, I tried to seek out. your
Objection, asked it, Your Honor, non-responsive. It's
Let me admonish him. It was a simple question, Mr. Silva.
I tried to reach out to your customer, to your client, so we could talk about expenses, and he was never available to meet with me.
okay. All right, sir, this is a different question, and that was asked and answered, Judge. Sir, it's a very, very simple question. And, you're not being cooperative here, sir, and I do not appreciate that in any form or fashion.
Knudsen, ask the question. I'll admonish the
Okay.
witness to be
Thank you, Your Honor. If he's not being responsive, if you can advise him appropriately, Judge. Did you give my client $12,000 in cash or a check? Yes or no?
For what, excuse me, objection vague, for what purpose, Judge?
He's talking about the insurance check.
Exactly.
I made several checks to Uber Transport for several different amounts during the course of the business.
Objection, non-responsive, Judge.
Judge, I'm answering the question.
Did you pay the $12,000? It's yes or no. Or if you don't know, say, I don't know.
Answer yes or no, or to that question.
I don't know.
Okay. Are you aware that my client's been asking and asking, where's my $12,000?
No, I don't recall.
Okay. You don't recall. Okay. And you understand if you keep funds that don't belong to you, do you know what that's called?
No, I don't.
Would that be a theft, sir? Do you think that would be theft, or is it okay for you to do that? To keep those 12,000 that don't belong to you?
Let's sustain, Mr. Knudsen. You're being argumentative again.
Do you think it's appropriate you should stay with those 12,000 in funds?
If they're for the operating business, I do.
Okay. And, okay. So where did the 12,000 go to? Did it go to the Lita Mosa operating account?
Judge, again, we're getting outside the scope of today's hearing. Mr. Knudsen is doing open discovery, and this is not for the purpose of determining ownership.
Well, Judge, this goes to credibility
Which is
on his statement, whether or not there's an agreement, the fact that he's kept $12,000 that belonged to my client on his truck is clearly
Mr.
credibility.
I know what the point you're trying to make, but I think you're going about it the wrong way. Ask another question.
Well, how should I go about it, Judge?
It's your case, Mr. Knudsen.
Okay. When were those funds received on the 12,000?
I don't remember, Judge, to be honest with you, I don't.
Was it more than 6 months ago?
From what I can recall, yes.
Okay. And what you're telling the judge, you haven't even mailed that check to my client, correct?
Objection, asked and answered, Judge. Said he did not.
Sustained. You already answered that question, Mr. Knudsen.
Okay. All right. Do you think it's appropriate for Lita Mosa to keep those funds, or you and your wife to keep those 12,000 that belong to my client on his truck?
If it's for the operating business, yes.
Okay. So you really think that, okay.
Objection, sorry. Bob.
Now, who was the check made payable to? Was it made payable to Lita Mosa, or was it made payable to my client?
From what I can recall, to Lita Mosa.
Are you sure about that, or you don't know?
From what I can recall.
Guessing. You don't recall, okay.
From what I can recall.
Okay. And if it wasn't payable to Lita Mosa, if it was payable to my client, you should have turned that over to him, correct?
Well, I did make several checks to Uber Transport for expenses.
Okay, objection non-responsive, Judge. Can you instruct the witness?
I know, Mr. Knudsen, but you're covering the same ground over and over again.
Okay, can I read back my last question? I don't think that was new ground, but I could be corrected.
Knudsen, you're covering accounting points that have nothing that go to the issues before the court right now. Whether your client's entitled to an ownership interest in this company,
Okay,
how the owners of that company manage their day-to-day accounting is an accounting issue to take up with the IRS and not for me to take up right now.
okay. Okay,
Your petition says that your client has an interest in this company, and
yes,
I want to know how you're going to establish that.
okay. I'm gonna get there with my client, Judge. And just so we're clear, you're testifying, and I think you already testified under penalties of perjury, that you paid and your wife paid y'all paid your all's insurance for your 2 trucks. Is that correct?
Objection, don't answer that. Objection, that's argumentative, Judge. Strike this to the statement that he committed perjury.
Yes.
No. Okay, I'll clarify it, but that's what your statement was, that I said, I didn't say he committed perjury. I said you stated under penalties of perjury that you and your wife paid.
That was what I wrote down. I'm sure that's what the record says.
Thank you. So is that correct, sir?
I don't even know what he's asking anymore. I mean, I'm sorry, Judge.
No, it's okay. It happens.
Yeah.
The
Okay, if you can listen.
I'll let you ask the question again, Mr. Munson.
Right. And just so we're clear, you testified under penalties of perjury that you and
perjury.
What?
Without the flowery language of perjury. He knows.
Okay. All right. I'll take out that flowery language, Judge. You testified under oath a moment ago that you and your wife paid for her 2 trucks that were in Lita Mosa, all the insurance, correct?
There were several insurance payments made, and I dispersed money to Uber Transport for expenses.
So is that a yes, that you did pay for all of the insurance for your wife's 2 trucks? Or you don't know now?
From what I can recall, yes.
And does Lita Mosa have funds? If my client paid 141,000, do they have the funds to pay it back?
Objection relevance. Objection assumes facts not in evidence.
Yeah.
It goes, go ahead, sir.
Mr. Knudsen, I'm trying to figure out how that's important. I mean, at this point, I know it is
Well,
trying to get a
if he
judge.
doesn't have the funds, Judge, I think it's important that we get a TRO to protect my client from what little, if any, is left there to reimburse my client.
No, I'm going to sustain the objection. The court will make that determination based on what it has before it.
Okay. Okay. So, all right. And you said monies were paid to your wife, Carmen, but none were paid to you. Is that correct?
Can he clarify monies, Judge?
Well, any monies. You said your wife was paid a salary, but you didn't know what it was. Your wife wrote the check, so you have no idea, not even a general sense of what it was, correct?
Objection asked and answered.
Okay, yes.
Is that an accurate statement, sir?
Mr. Knudsen, you can ask him, if you want, ask him if he was paid any salaries or monies from the company.
Were you paid any salaries or monies from the company, sir?
From what I can recall, no.
Okay. And if you were paid, it would have been a nominal, like less than $2,000?
Objection, Judge, again.
Answer if you know,
relevance.
Mr. Sutton.
I don't know. Don't know.
It's certainly, if it was more than 10,000, you would certainly know about that, correct?
Depending on the time of what we're talking about, there was, at the beginning, the trucks that were purchased, the profits were supposed to be taken on those trucks. There weren't any profits paid out on those trucks.
So you and your wife never got paid any profits on the 2 trucks, is that correct?
Objection, it misstates the witness's testimony.
Sustained.
Let him answer, Judge. He's coaching them. Subjection, relevance, objection.
Re-ask your question. Re-ask the question.
Were any profits taken out from your wife's 2 trucks ever?
No.
Is that correct?
Just answered it, Mr. Knudsen.
What?
Just answered no.
Okay. Were any profits paid to James Pettis on his 2 trucks?
Calls for speculation, Judge.
No, if he knows, you can answer if you know.
During that time, James Perez was managing it. I don't know.
Okay. Are you willing to sit down with my client this week to go over the numbers? You can answer, sir. You don't have to look at your attorney.
Yes. Yes.
Thank- Okay. Are you available Thursday or
We
Friday?
gotta make appointments right now. Move on.
Okay, all right. And we'll take you, for the record, we'll take you up on that.
Talk to his attorney, Mr. Natsa. You know how it works.
Yes, I do. Should have been done 6 months ago.
No sidebars, Mr. Natsa. Do you have any
Okay.
further questions for Mr. Sedla?
Yes, I do. Were any monies paid from Lita Mosa for personal expenses of you and your wife?
There were monies that were used to, for the completion of the remodeling of our house.
About how much?
I don't know
Objection,
those.
relevance, Judge.
The answer. He doesn't know, Mr. Natsa.
Okay. And those were some that I rent out, like Sherwin Williams, Lowe's, for lumber and things of that nature, correct?
That's correct, but they were paid back into the
They
company.
objection, volunteered, the last part, Judge.
You're both volunteering, Mr. Natsa.
What?
Mr. Natsa, we can cover all the accounting.
It was not responsive, Judge. The last part was non-responsive.
I'm gonna make a decision in about an hour, hour and a half. So
Okay.
you get to the point.
Okay,
If you want to keep covering the accounting, I'll do that. But this is
Okay.
case in chief.
all right. Vanessa, can we bring up the one that says Lita Mosa bank account? Okay,
You have a copy, Mr. Thomas?
I believe so, Judge. I think I was going to, yes. sir.
I'll mark this Exhibit B. Where did you have your bank account with Lita Mosa, sir?
We have it at IBC.
Okay. And isn't it true that my client had, you gave him access to this bank account?
For a short time, yes.
From when to when?
I don't know the exact dates.
Okay, short period of time, would that be like 30 days? 6 months? How long?
The access was given to him to show him that we did not have money in the account. And probably less than 30 days.
Objection, Your Honor, non-responsive. Can you instruct the witness?
The answer there at the end, 30 days.
So you said it was only 30 days, is that correct?
From what I can recall, yes.
Okay. Okay. All right. And on 8/31/2020, there was a check for $8,000. Do you know who that was to?
No, I do not.
Okay. And all those other checks, 7,000, do you know who that was to?
No.
And Zarsky Lumber, that would have been for your home?
Objection, relevance, Judge.
I'm gonna let him present his case, Mr. Thomas. If that's how he's gonna prove up his case, I'm gonna let him do it.
Yes, sir.
From what I can recall, yes,
Same thing with Home Depot?
correct.
And this withdrawal, $4,800, was that to pay workers at your home?
I don't know.
Do you know what it was for?
No, I don't know. It was back in, this says July. I don't remember.
Yeah.
2020.
Exactly. I mean, normally you write checks to people for gas, things of that nature. You don't withdraw cash, do you?
Objection. Judge.
Well-
Or do you know?
Answer if you know, Mr. Sedler.
No, I don't know.
And the 5,000 check and $3,200 check, do you know what that's for?
No, I do not know.
Okay. When did you do the remodeling of your home?
Okay, Mr. Matson, again, Oh, do you plan to cover every withdrawal? Is that what we're doing?
No, I'm just kind of going through highlighting some of the main items, Judge.
Well, I understand that, but as I mentioned, the only documents that I've seen produced by both sides indicate that they're the owners of the company.
Okay,
How they spend their money right now doesn't help me determine whether or not your client has an interest.
yeah. Okay. Well, let me move on. Let me ask, when did you do the remodeling on your home from, how long did it take to do the remodeling? 5 months, 6 months? How long?
Mr. Knotts, I'm going to give you 15 more minutes with this witness, and then I want to hear from your client.
All right, go ahead, sir.
Do I answer?
I'm sorry, I interrupted the question. Can you ask the question again? I'll give you some time for cross if you want, or you can wait for.
Did you understand the question, sir?
No, please ask it again.
When did you do, how long did it take to do the remodeling on your home?
The remodeling took almost a year and 8 months because we stopped during COVID and then there were other delays.
Okay.
That took
When
place.
did it start and when did it end? Thank you.
I don't know the exact dates, Judge. It's
Approximately, sir. When did you finish the remodel?
we finished the remodeling. I want to say June.
Of what year?
Of 2020.
This year?
No, 2020.
Oh, over a year ago, correct?
Yes.
Okay. So it would have been from about January 2019 to June 2020, correct?
From what I can recall, yes. I don't recall the exact.
Okay. And that would be about the year, well, a year and 8 months. So it'd be an extra 2 months, but all right. And James Fettis, you consider him an honest person?
I mean,
You know, Mr. Settler.
no, I do not.
Okay. And why not?
Well, he came to me promising $700 profit on each truck, and I never saw a dime.
Anything else?
No, that's it.
All right. Do you agree that someone that doesn't abide by their promise is not being honest?
I think it's objection, Judge. It's already been asked and answered
Yeah,
multiple
you're
ways.
being argumentative again, Mr. Knotson.
Okay. Okay. So you don't have anything in writing as to what the agreement is that you had with James Fettis, is that correct?
I do not have anything in writing. I cannot recall, no.
Okay. Okay. Okay.
Are you done, Mr. Knutson?
Let's see, did my client pay, expenses from his personal checking account that you're aware of, like 25,000?
Not that I'm aware of, no.
Okay. Okay. And, okay. Did my client send checks to Lita Mosa to fund the operations?
Not that I can recall, no. Checks?
Yep.
Not that I recall.
Make any deposits to Lita Mosa?
There were deposits made for expenses of operating
Expenses
costs,
on what?
which were reimbursed to Uber Transport.
Okay, objection non-responsive. Your Honor, can you instruct the witness to answer only the question asked, Judge?
Problem is,
Or to
Mr.
object to the last part as being
You're
non-responsive?
asking multiple questions, so if you want your answers short, keep your questions short.
Can I have the correct question read back, Judge?
No, ask the question again.
Sir, can you hear me, sir?
Yes, I can hear you.
Can you only answer the question that I asked? Could you be so kind to do that, sir?
If I understand the question, I will answer it.
All right. Were there deposits by Mr. Perez to Lita Mosa?
Objection asked and answered.
Answer it again.
There were deposits made for.
Thank you. And do you know how much those deposits were?
If he can be allowed to answer that question. fully.
Yeah,
He cut him off and it's
You-
a
you-
witness's right to answer that question.
yeah, you can clarify during your redirect, your cross. And the question was, the next one, Mr. Knutson? And you've got.
Yeah. And what were the deposits by James Perez? Do you know how much those deposits were?
No, I do not recall.
Okay. Thank you. Was there a monthly, weekly, would you or Lita Mosa send them, hey, your portion of expenses is 1,000 this week, please send a deposit? Did you ever have a written paper trail? Hey, here's your portion of expenses, please make this deposit. Yes or no?
There was never a consistent paper trail of what we were doing. No.
Okay. And did y'all ever ask Mr. Perez, hey, we need X amount for expenses for the whole company, please make it?
I'm sorry, the question again?
Were there any communications with Mr. James Perez where he was advised, hey, we need 5,000 for expenses for Lita Mosa, please make a deposit?
There were expenses paid, which were paid back to Uber Transport.
Okay, objection, non-responsive.
Overruled.
I'd ask that the answer be stricken, Judge, and I'll ask the question again, or,
Overruled. You've got 5 minutes.
okay? Okay. Do you believe it's appropriate to steal from your own cousin?
Don't answer that. Marcel, you know better, Mr. Knutson. Ask another question.
Okay. Isn't it true you and James Perez agreed that you all were going to be 50-50 co-owners of the company?
Objection
Don't
asked
answer
and
that.
answered.
He's asked to answer that question multiple times, Mr. Knutson. Ask another
Okay.
question.
Okay. How much money did you pay to your attorney? Did you pay personally or from corporate funds?
Objection, I'm going to instruct the witness not to
Don't
answer.
answer that. Ask another question, Mr. Knudsen.
That's all I have, Judge.
Judge, I'll withhold my questions until our case in chief.
Your next witness, Mr. Knudsen.
I'll call Miss Cerda.
Good afternoon, Ms. Sutton.
Good afternoon. I stand here.
Yes. Can you raise your right hand so the clerk can swear you in?
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Before you begin, Mr. Knudsen, everyone okay to keep going?
Yes.
Staff, not you, Mr. Knudsen.
Oh, I mean your staff. Okay, I'm sorry. I guess you're calling me a nobody, Judge, or I'm joking. Can I have more coffee, please?
All right, let's proceed. Your first question, Mr. Knudsen.
Please state your name for the record, ma'am.
Carmen Guadalupe Cerda.
Okay. And what's your date of birth?
1/16/79.
1/16/79.
Yes, I'm 42 years old.
Okay. And you're married to Jaime Cerda?
Jaime Alfonso Cerda, yes, for 14 years.
Okay. And did you all approach James Fettis about this business opportunity?
No.
Okay. Then how did you all do this business opportunity?
So I'm going to speak. Around 2016, James Perez started asking Jimmy and I if we wanted to buy 2 tractors. Come on, let's do it. I was a teacher. He was a regional manager for FedEx. We were fine, hardworking people. We were fine without the tractors. So for about 2 years, he kept persisting for us to buy 2 tractors. So then, yes, we were convinced. We asked my mother-in-law for the money and we purchased the tractors. He promised me personally, he showed me a check payable to, I can't remember who, $700. And he told me to my face at my house at the time, 1901 Fremont, he told me, you will be making around $600 to $700 a week per tractor. Oh, awesome, great. Okay, that went on for 2 years. We never saw $1. Not
So why
one
didn't you close the
dollar.
company?
I'm sorry?
Why didn't you close the company in early 2000?
You know what, Mr. Knudsen, at that point, we trusted Mr. Perez and we kept giving him chances. And he kept
But-
saying that the tractors weren't making money. Not even our accountant at the time could believe that we were not making not even $1 in a month.
Who is your
I'm
accountant,
not gonna disclose that.
Your Honor?
Not relevant. Next question.
Okay, so you think it's okay to hide stuff from the court?
No.
Objection,
Mr. Don't answer
argumentative,
that. Yes.
Judge.
Next question, Mr. Knudsen.
Now, the 12, how much do you get paid? Your husband said that you write your own checks. How much do you get paid?
It varies. It varies depending on how the week is.
Okay, more or less, give us a range, please.
Around more or less $2,000. But let me tell you one thing. If the company is short that week, I pay it back.
Okay, so about 2,000 per week, correct?
Yes. Mhm.
And is it correct what your husband said, that James Fettis hasn't been paid anything?
Objection. Judge, what do you mean anything? Can it be more clear?
He hasn't been paid a salary. He's never been paid.
Clarify the monetary sums that you're referring to.
Okay, he's never been paid a weekly salary.
He has
Or
never
range.
been paid a weekly salary because he's not employed by Litamosa.
Okay. But you said you all were doing business together, correct?
Oh, that was back in 2018, Mr. Knudsen.
Okay. Are the trucks still working there?
Objection vague, where's there?
Clarify which trucks you're referring to, Mr. Nelson.
Okay. Your husband said you purchased 2 trucks under your name, correct?
Yes, a 2012 and a 2014.
And Mr. Pettis put in 2 trucks he had, correct?
That's correct.
And y'all were operating 4 trucks, correct?
I can't say that. I can't answer that because I don't know if they were operating or not, because we never knew of anything. He was managing the 4 trucks at that point.
Okay, how many trucks are operating right now?
How many trucks are operating right now for Lita Mosa? Lease under Penske, 11 trucks.
All right, okay. So it's not 4 trucks as your husband testified to earlier.
Objection.
Now we're getting to the truth, the whole truth.
Well, he meant the,
Objection.
Yeah, don't answer that.
Okay.
Sustain. You need to clarify.
Okay, so there's 11 trucks. 2 are yours, 2 are James Pettis, and the other 7 are leased from Penske. Is that correct?
no, that's not correct.
What is it?
Two of my trucks are down. Those were down since James Pettis were running them because according to him, they were no good. One truck, to my recollection, one of James's is the one you claim that we kept the money. And the other one, I don't know where James is at. I don't know. These Penske trucks are totally separate from the 4.
Okay, so there's, and thank you for clarifying that. Just so we're clear, there's 11 trucks that are operating for Lita Mosa that are leased from Penske, correct?
Correct.
And if you're not making any money, when did that lease occur? A year ago, a week ago?
Are you gonna let me answer or because you just asked me a
Sure,
question?
go ahead.
I don't want you all to start arguing with
No.
each other. Okay.
It was around June. It was around June 20th, I believe. I don't recall when we started the lease agreement with Penske.
June 20th of what year?
I just said, 2020.
Okay, 2020, okay. So it's been about almost 16 months, correct?
If we do the math, yes, I believe so.
Thank you, ma'am.
Mhm.
Now, if you were not making any money, no competent businessman would enter into a lease. Would that be a fair statement?
What's your
Objection
question,
vague,
Mr.
Judge.
Knudsen?
I'm not
Yeah.
sure I understand the question.
Yeah.
Your Honor, can we have the court reporter read it back
No,
or
I
tell her
have
what it was?
question. You're asking them to make opinions on their business decision strategy. It doesn't, it's not helping
Okay.
Mr. Knudsen.
Well,
You-
ma'am, your husband's insinuated,
Mr. Knudsen, your petition alleged your client had a business interest in their company. So
yes,
far, we're only covering their finances and how they spend their money from the company. How is that supposed to help me understand your petition?
okay. Well, okay, let me move on, Judge. Ma'am, did, let's see. Was there anything your husband testified that you think was inaccurate?
No, sir.
Okay. Okay. Um, have you ever lied to the IRS?
Objection,
Don't
Judge.
answer that.
Relevance and
Yeah.
objection.
Mr. Knudsen, ask another question.
Okay, ma'am, on your exhibit number 3 to the IRS, we'd ask that that be admitted at this time. Any objection?
No objection.
That defense exhibit number 3 will be admitted.
Okay. And if your attorney can show you,
But that's Defense Exhibit 3.
correct,
You only have 2 exhibits, 1 and 2.
Right.
correct?
correct.
Exhibit 3 is Defense Exhibit 3. Is
That's
that
correct.
It says Lita Mosa Logistics LLC, Carmen Cerda, sole member. That's false, correct? It's more
Check.
than one member, correct?
Objection, Judge, relevance.
Mr. Knudsen,
It's completely relevant, Judge.
yeah, I'll let her answer. I mean, I've seen that document. If you want to clarify what's on there, I'll allow that.
Judge, can we give the witness
A copy.
a copy of the questions that Mr. Knudsen is asking about? I have can I get it?
Let me look at it first and I'll
Yes.
hand it to the witness.
Yes.
And this would be the same, I provided these to opposing counsel.
No, and I had a copy. I just didn't print all of it.
Are we talking about exhibit 3 or is it exhibit 3, counsel?
Exhibit 3, yes, sir.
Just for the record, this is the employer identification receipt from the Internal Revenue Service.
And that shows that you're the sole member, and that's not correct, is it?
Here you go, Ms. Sever.
It says that I'm the sole member, yes,
And that's not correct, is it?
it's correct.
Okay, so your husband's not a member of the company?
Yes, he is.
Okay. So that document is incorrect.
As per the IRS, it says Carmen Cerda, but my husband is a member of the company, yes.
And so is Mr. Pettis, correct?
I don't see Mr. Pettis here, so no.
Okay. Well, I don't see your husband on here on Exhibit 3.
Good point.
So he's not a member?
Asked and answered, Mr. Knudsen.
Okay.
Point's been made.
Judge, can we take a break?
All right. Thank you, Judge. Okay.
Mr. Knudsen,
Who was the check
Mr. Knudsen.
on my client?
Hold on.
Excuse me?
Hold on, Mr. Knudsen. I'm going to give the staff a 5-minute break.
Okay.
And then we'll let you resume your questions.
All right, thank you.
I want to tell you, Mr. Knudsen, I don't plan on going past 5:30, so you need to decide. At that point, then
Okay.
we may.
I'll try to be
depending on
quicker with
what
this
we
client.
are- No, I'm only going to allow you up to 5:15 to put on your case. So you need to, in this 5-minute break, decide how you're going to do that.
Okay. All right, thank you, Judge.
All right, we'll be back in 5 minutes. Yeah, I was gonna say, I was about to tell you, hey, don't forget the camera button.
Ahí está, ya te lo apagué. Ya te apagué la cámara. You know how to turn it on?
Well, I don't need to, I'm gonna go back up.
No, no, ahí está. So you don't want it on?
Because it doesn't need to be, on, it's just a picture.
No, here.
No, it's turned on. No one's in here moving.
Yeah.
Unless someone's in it. Look, yeah, that one.
Okay, Judge, I'm back. Is your staff ready, Judge? You're on mute.
Mr. Clayton, you ready to go?
Yes. I'm ready. May I proceed?
Hold on. Okay, you may proceed, Mr. Knudsen.
All right. Let's see, where's my phone? Ma'am, you understand you're still under oath, correct?
Yes, sir.
Okay. And, okay, who negotiated, who's the primary person that negotiated these leases with Penske?
Who's the primary person that negotiated the lease with Penske? I believe it was the management that we hired, which was Elias Mendiola.
Elias Mendiola Jr., correct?
Yes,
And that's my client's first cousin, correct?
correct.
And Sandra Mendiola with Remax, that's his first cousin, correct?
I don't know who that is, sir.
The realtor from Remax, the blonde, you don't know who that is?
Oh, no, I don't. Sorry, no, I don't.
All right, and isn't it true my client paid $35,000 down payment with Penske for the leases?
No, it's not true.
Okay, and you're stating that under oath, correct?
Correct.
And so you're telling the judge that you and your husband are the ones that came up, it was 5,000 down for each of the 11 trucks, is that correct?
To my recollection, Mr. Knudsen, since it was COVID at the time,
Yes, no.
I need to explain this a little bit. I need to go back to my emails, but as per the sales rep, there was nothing given down at the time.
Okay, so are you aware that my client paid $35,000 for 7 trucks with the Penske leases?
No, I'm not aware.
Okay, are you aware that you and my client were going to split those proceeds 50-50?
No,
Are
I'm not
you
aware.
aware that there was negotiations going back and forth with my client to negotiate the Penske leases?
no,
Are you aware that he was sent a copy of the lease on the 11 trucks?
not correct.
Okay, it's not correct or you don't know? So any emails you got from Penske on the lease, he was never carbon copied. Is that what you're telling the judge?
That's too many questions. Can you ask the first one and then we'll take it from there, please?
Your Honor, I don't know, I see a David Garcia. Is that your office or is that the attorney David Garcia?
No, that's my chambers.
Okay, I just wanted to see if there was another attorney involved that hadn't made an appearance. Okay, so are you telling the judge that my client had nothing to do with the Penske leases?
I never said that, no.
Okay, to your knowledge, did he have anything to do with the Penske leases?
He didn't have anything to do with the leases because I was the only signer for that. I went over the lease and the contract and I signed it. Maybe he negotiated with his cousin Elias with Penske, but as far as he having to do anything with the leases and signing and confirming the contract, no, he had nothing to do with it.
And didn't you all agree that he was gonna get 50% from Penske and you were gonna get husband
Mr.
get
Knudsen,
50% from Penske?
No,
So yes or no?
I never spoke to Mr. Perez.
Okay.
We,
Did
no,
you and your husband agree to that, to your knowledge?
nope.
Okay. So you're with your husband 24/7, or you don't know whether or not he could have agreed to that?
Argumentative, Judge, and
Yeah,
the
Mr.
question.
Your Honor, I'm just trying to get actual
We're asking you
testimony.
to speculate.
Okay.
On it, Mr.
All
Secretary.
right. So you don't know if your husband agreed to that because you've never been present with him 24/7. Is that correct?
I don't recall him agreeing to that.
Okay. And are you aware that did Mr. Bettis pay $10,000 down for the insurance on the leased trucks?
I'm not aware how much, but I am aware that we reimbursed him to Uber.
Okay. So my question is, he did make payments for the insurance, correct?
And my answer was, I'm aware he made some on behalf of Lita Mosa. I don't know, I'm not aware how much or to who or what.
Okay. Fair enough. Now, if he's not going to be an owner getting 50%, why would anyone make a payment? Just because he's a really nice guy, or do you know?
Maybe because since he hadn't paid us for 2 years, the profit on the first tractors, maybe he
Okay.
felt he had to. I don't know.
Objection, speculation, Judge.
That
Call
was
for
your question.
speculation.
That was your question, Mr. Knudsen.
Okay. Do you have any personal knowledge of that, or you're just guessing, ma'am?
Personal knowledge of what, sir?
Do you have personal knowledge of
No,
any
that's-
amount that were due to you that he didn't pay? Or are you just guessing? Is what I'm trying to find out. The judge doesn't want you to guess.
I'm changing the question a
I don't
little
know, yeah.
bit. The question was whether you know why he made that payment.
Do you know? That means when you say you know, I know, look, he owed me 10,000, so he paid 10,000. But if you don't know he owed you 10,000, it's just guessing is not, that's called speculation, ma'am.
So
Do you
as-
know for sure why he made that payment or not?
Judge, he's badgering the witness.
Yeah, you need to break your questions up. You're confusing me.
Okay. Do you know why he made that payment? Yes or no?
No,
Okay, thank you. It's very simple.
Right, Mr. Knudsen.
All right.
Judge, I'm going to object sidebar. Again, he's getting argumentative with my witness.
No, I'm done, Judge. I'll call my next witness.
Want to reserve?
I'll reserve.
Mr. Knudsen, thank you, Mrs. Silva.
thank you.
Mr. Perez, are you there? Can we call Mr. Perez? You must have got cut off, Judge.
I don't see him in here in the lobby.
Is he being let in? I think during the break, he had to hang up to call me at my office, and he said he was joining back on right before I came on. Miss Vela can check that.
I'm checking.
He's coming in.
He's coming in.
Okay. Was he in the waiting room all this time, or? Hello, Mr. Vela. Were you in the waiting room all this time?
Yes, sir.
Okay. Well, Judge, okay. All right. Well, I asked various questions of the witness that you weren't able to hear, but if we can swear in my client, Judge?
Can you please raise your right hand to be sworn in, Mr. Perez?
Yes, sir.
Good afternoon.
Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name for the record, sir.
My name is James Perez.
Okay, and how old are you, sir?
I am 50 years old.
And are you related to the defendant, Jaime Cerda?
Yes, I am.
And tell the judge how you're related.
He's my second cousin. Him and my mother are first cousins.
Okay. And are you related to Elias Mendiola Jr.?
Yeah, I'm related to all of them, to Junior and a third. One's my uncle and the other one's my cousin.
Okay. And all right, here you, Vanessa, do we have the verified petition to bring up? You signed off on this verified petition, is that correct?
Yes, I did.
And you understand you were swearing under oath that the statements were true and correct?
Yes.
Now explain to the judge, what agreement did you have with Jaime Cerda and Carmen Cerda?
Our agreement was to start moving trucks together. And at first we had 2 and 2 trucks and we were 50% partners, my 2 trucks and those 2 trucks. And then we were running, his 2 trucks broke down and we didn't really run. And then my trucks kept on running till one wrecked and then I stopped the other one. At that point, or when mine were still running, we ended up having my other cousin, Elias Mendiola, negotiate with Penske to lease newer trucks.
Right.
So we could keep on running it.
Hold on, Mr.
Excuse
Pettis.
me?
Yeah, there's an objection. When there's an objection from the attorney, just pause so I can rule. And Mr.
Okay.
Knotts can proceed in question and answer because.
All right.
I'm sorry.
We'll try to keep the answer brief and then I'll ask a couple of different questions. So, and we heard from Mr. Pettis, they put in 2 trucks. Did they ever tell you about the 2 trucks that they were going to buy?
Yes, they did. And I
And what
advised
did
against
you
it.
advise them?
When we bought, like, for example, the 2 trucks, they were trying to buy these Peterbilts with Max 4 engines. So they're cheap trucks and they break down a lot and it's hard to get points versus my trucks that were Freightliners cost $50,000 a piece and were better at running. I advised in them buying those 2 trucks. I said, wait, let's look for a better truck to buy. And they did not. They went, they purchased them. So I said, okay, they purchased them. I ended up driving 2 drivers all the way to North Texas to go pick up their 2 trucks and bring them back down to Laredo. And I paid for all the expenses to bring those trucks down.
Okay.
Yes,
Did you
I
ever
paid
get
the drivers, I
reimbursed?
paid the diesel and all the expenses.
Did you ever
No, I
get
did not.
reimbursed for all those? Okay.
I
And
did not.
so they're fully aware of all these expenses and their 2 trucks ultimately, as the wife stated, were not even working. They're not even, haven't been working for a while, correct?
Do you want to object to the comment?
No,
The question, Judge?
Break your question up, sustain, Mr. Knotts.
Yeah. I believe Miss Perez Cerda testified that her 2 trucks had not been working for a while. Is that accurate?
correct. You can check the miles on them. They were barely running.
Okay. And so you paid a lot of the expense. What was your understanding of Lita Mosa, who the owners were going to be?
We were, at least Mosa, we were supposed to be 50-50 owner oral agreement. It's my fault that we put it in writing, but I trusted them, so I didn't think anything about it. I had no reason to not trust them. So I allowed it. And, you know, when we started leasing the trucks too, it was on 50-50 owner. I put in all the money for the down payment. I paid all the insurance down payments, and I paid the insurance when the trucks weren't running. When we first started, I was paying that out of my pocket as well.
Okay. And that's what you're owed back from Lita Mosa, correct?
That's part of it. I also paid for drivers, for fuel, for all kinds kinds of other expenses that I was never reimbursed for.
Not only your drivers, but their drivers on their 2 trucks, correct?
Judge, I'm gonna object.
Correct?
For the question.
The what nature?
Leading, he's leading.
You're leading your witness, Mr. Sustain.
Okay.
All right.
Who paid for the drivers on their 2 trucks?
I did.
Who paid the insurance on their 2 trucks?
I did.
Who paid
And I have the receipts
almost
to prove it.
the repairs on their 2 trucks?
I did.
Okay. And you haven't been
And the
reimbursed?
towing as well from out of town.
Have you been reimbursed all
No,
of those
never
funds?
been reimbursed.
Is that why you
No, I
filed
have
the
not.
lawsuit? And you saw the letter?
Yes.
You wanted,
I want my,
you authorized me to send that letter on May 13th?
yes, I did.
And Jaime Cerda said he called you numerous times to meet with you, but you just blew him off. Is that true?
No, that's a lie. From the day he got the letter, I had never heard from him.
Okay. And if he did call you, would you have met with him?
Yes, I would have. I would have referred him to you because I already had hired you. And if you would have called me, I would have told him to talk straight to you. We can check phone
Okay.
records. He did not call me, not once.
And he said he's willing to meet this week. Are you willing to meet this week?
Yes, I am. I just
Okay.
want this to come to an
And-
end.
Okay. And you just want to get paid what you're due, correct?
Correct. And actually my half of the profits, because if it wasn't for us and for Elias, the negotiating we do, they wouldn't have those Penske trucks. They didn't have the first clue on how to get that. So I believe that I'm due half of everything,
Exactly.
which was the
What
agreement.
was the agreement on the Penske? How much were you supposed to get from that?
The Penske trucks, when they were running every week, we had a spreadsheet that we would do all the expenses in the fuel, and whatever was left over was supposed to be divided 50% to me and 50% to Jimmy and Carmen.
Okay. And did you have conversations with anyone at Penske?
Yes, I did. Both me and Elias Mendiola talked to him.
Okay. And is everything in your original verified petition where you were supposed to get reimbursed this $141,425?
The agreement we had when we started with the Penske trucks was all the money I put in to get the trucks going. Once the trucks were running, the first profit was supposed to be used to be paid back to pay me back for all my stuff. They had even said that they were going to get an SBA loan and then pay me back at that time, and they never did.
I'm gonna object, non-responsive. The question was,
It's
specific,
responsive, Judge.
Well,
the specific amount that's
All
listed. in the petition.
well, hold on. Yeah, let's move on. So noted.
Okay. So they told you they were going to get an SBA loan to pay you back, correct? So they
Correct.
admit they owed you the
And they
money.
even sent me, I have emails. Yes, and I even have emails where they sent me copies of when they were dealing with SBA and that the SBA had sent it to the wrong bank account, which I think was a lie. I think they kept the money, but they kept on giving me these excuses over and over that they never had gotten the money. And like I said, the agreement was, though, when we started being profitable, the first profit was supposed to pay me back all the money I had put in for insurance, down payments for the lease, fuel, and for everything else I did.
And all those monies, that's the at least 141,425.60, correct?
Yes, it's probably more, but I don't have full access to the Lita Mosa account to see exactly what they spent and what I put in there, but that's a minimal amount. I'm sure that if we research it further, there'll be more.
All right. And they testified under oath that you only had access to the accounts for 30 days. Is that true?
That last time we were running the accounting from my office, I have the QuickBooks that shows we're doing it. Then around December, Jimmy came and said that he was going to start doing the accounting. He stopped my office people from doing it. And then I lost track of that and I had never checked. And when I started seeing suspicious activity, I asked him for the password. He wouldn't give it to me, wouldn't get to me. We're going back and forth. And finally on a text after all this, asked him what was he hiding, this and that. He gave it to me. And at that time, I was able to go in there, download everything. And then a few days later, he changed the password on me again. And I wasn't able to look in there. And he even admitted there in the text that he had used a bunch of money and he had gotten at the pawn shop. They wasted a bunch of money and on their own, and it wasn't for the company. And that's why they weren't paying me back.
Thank you, Mr. Pettis. Try to answer the question that Mr. Knudsen is answering. Sustain.
Okay. And so here, basically, basically you understand you're under penalties of perjury also, just like they are, correct?
Yes. Yes, correct,
And
sir.
have reason to lie to the judge, sir?
No, I do not.
And are you disappointed that your cousin hid this information from you and stole from you?
Objection, Judge. Argumentative.
Yes, I'm disappointed.
I'm just going to allow it. Go ahead.
I
Did
never
you
expected that from them.
Did you trust that are you shocked that the business is only under their name? 100%.
I'm shocked
That's
that
what they're
everything they
claiming.
did,
It's
I never,
only under their name.
Okay, Mr. Knudsen, the point's been made.
well, in writing.
10 minutes.
Okay.
Sorry.
And basically, you trusted that they were going to put the corporation as you all agreed, correct?
Objection. Easily.
Yes.
Objection asked and answered.
Yeah.
And
Re-ask
do
the-
you believe that that's fraud, sir?
Don't lead your.
Yes, I do.
Judge,
And tell the judge why.
Judge,
Tell the judge why.
Judge, there are objections on the record that Mr. Knudsen is completely ignoring, and the court is making rulings on those
Yes.
objections that Mr. Knudsen and his witness are
Okay.
completely ignoring.
Okay, Mr. Pettis, when there's an objection, you need to stop talking until I make a
Oh,
determination.
I'm sorry, sir. I can't hear the objection, sir. I'm sorry.
Okay.
They need to
Can
speak
you
up a little
tell
bit
the
louder.
judge? Can you tell the judge why you believe they committed a fraud on you?
It boils down to I trusted him. I never thought Jimmy would do something like that, screw me over. I'm sorry about the words. I mean, I was putting money into the business. I thought it was understood. We had talked about it. We were 50-50 owners. I never thought it would get to this point where I'd have to file a lawsuit.
And if they had called you back in the last 6 months, we wouldn't be here, would we?
Objection.
Correct. I just wanted my money back.
Okay, sustain, you're leading it
And the
with.
basis for the objection, Judge?
Leading.
Okay.
Counsel, can you hear me?
And do you believe we would be here?
Hold on a second.
Hold on, just
Question?
just for technical reasons, Mr. Knudsen, can you hear me?
No. Why is he on mute?
I think he's on mute, just so if not, it's going to echo, Judge. But I can hear him.
It says 341st where he's saying he's mute.
Yeah, but that's the
Can you hear him?
tablet.
James, can you hear Mr. Tames say something?
No, I cannot. No,
Say
I
something.
can hear you and I can hear the judge.
Mr. Knudsen,
People,
can you hear me?
talk?
Mr. Knudsen,
I can hear you perfect. Can you hear the
I can
lady?
hear that.
Standing right
Yes,
next to
I can hear the lady.
All right,
You
let's,
can maybe get a little closer.
let's proceed.
Okay. Okay. And item okay. Now here, pull up paragraph 13, sir. Vanessa. We're going to pull up your petition. And I need to go pretty quickly, so go to page 3, right there. It says, despite this agreement, defendant Cerda did not distribute per the agreement, instead secretly distributed to themselves or their personal benefit about $245,708 without first paying James Pettis $141,425.60. Is that correct?
Yes, that's correct.
And where does the 41,425? can we pull up the Uber transport expenses?
That expense
Well,
comes
that-
from my personal account, from my freight forwarding company account, and from my Discover card. I use all three accounts to pay stuff.
Okay, go down.
Judge,
We'll mark this
Hold on a
as
second.
exhibit.
Mr. Knudsen, second.
I don't even know which document, Judge, we're
I
looking
think
at.
it's this one, January expenses.
Uber transport.
Yeah.
Uh,
I've seen, you can use,
Okay, and this is,
Sir, and this is, I'm marking it for identification, plaintiff's exhibit 3. Does this identify the funds that you paid on behalf of Lita Mosa?
objection, Judge, this exhibit hasn't been admitted yet, Judge.
I'm laying the predicate.
That's not the proper way to lay a predicate, Judge.
ask him questions about the exhibit.
Okay. Sir, does this reflect where the 141,425.60 comes from? That what is the 141,425.60? Tell the judge what that is.
Objection, it's a proper predicate, Judge. He's already asking the witness questions about an exhibit that hasn't been admitted into evidence.
Okay. I'm asking him to explain where it comes from, Judge.
He has to lay the
I
predicate.
wrote,
We can ask questions about
Hold
the
on, Mr.
document.
Temes. I'm gonna allow it. Go ahead, Mr. Knudsen. You've got
Thank you, Judge.
minutes.
Explain where the 141,425.60 comes from.
that spreadsheet is it comes from my company, Uber Transport Freight Forwarding account, from my personal account, and from my Discover card. I was paying for down payments for the insurance. I was putting down payments on the Penske trucks, which was roughly 5,000 down payment on each Penske truck and roughly 10,000 down payment insurance on each truck. I'm not sure the exact amount, it's just approximate. And then I also was paying fuel. I was paying the drivers. I have all the receipts to pay. I was paying repairs on Jimmy's broken trucks. I paid repairs on my trucks when they were running. I paid, like I said, fuel, drivers, anything associated with a company when we were starting it, I paid it out of my pocket for Lita Mosa.
Okay, because the company had no money when it started, correct?
No, they had no money. They were in debt because of what they were doing.
Yes,
Objection. Can you hear me, Mr. Knudsen?
yes.
Yes. Go
Leading.
ahead.
You're leading the witness again. so
Objection
stay-
vague. Which company?
Okay, how much money did Lita Mosa, we're only talking about Lita Mosa, Judge. Is there another company we've been talking about the
Just
last
ask
2
the
hours?
Mr. Knudsen,
I mean, I don't understand. Objection to his objection is being
Ask the
unintelligible.
question. You want to spend the rest of your
All
time
right.
arguing with the court?
No, sir, how much money did the company have when you all started it?
Lita Mosa had zero money in it.
Thank you. And explain the 42,276.01 that Uber Transport, is that, where did that money go to? Where did that 42,276.01, where did that go to? Who did it go to?
It went to pay expenses for Lita Mosa, like I said. We
Okay,
paid the
and the
insurance
personal
down
credit
payment.
card, hold on, because we're running out of time here and I'm trying to get this in. The personal credit card, is that your personal credit card?
Yes, it is.
And the $74,055.33, is that, where did that money go to, for what expenses, for what company?
It went for Lita Mosa when we put tires on the truck, for any parts I needed to install the electronic logs and pay for the electronic logs. It went for all kinds of expenses to get the truck started. Trucks don't just automatically start.
And the personal checking account, whose personal checking account is that?
That's mine.
And 25,094.26, where did that money go to?
To pay the drivers that were driving the Penske trucks for Lita Mosa.
Okay. So you have all that document, and these are true and correct summary of the records that you have. Is that correct?
Yes,
This is
I have
3.
all the receipts. Yes, sir.
And this is a summary of all the receipts that you have, and this is kept in the ordinary course of business, correct?
Yes.
And
And there's
this is
more.
where you are swearing under oath that the 141,425 and 60 cents is the minimum amount that you can prove right now that went to Litamosa, correct?
Yes.
And they agreed to reimburse you that funds and then split. What was the amount of the split after you got reimbursed?
After I was reimbursed, the split was supposed to be 50-50 the profits, and we had a spreadsheet to work it all out.
Last question, Mr. Knudsen.
Okay, so did you all have a spreadsheet that showed that?
Yes, we did. I did. I kept on showing it to Jimmy, but he was trying to ignore it because at that time, I believe they were already doing funny stuff.
Okay,
All right,
and
Mr.
you're asking that the court grant the temporary injunction just.
Mr. Knudsen, last question, you already asked it. I'm gonna
Okay.
allow a few minutes for Mr. Tames to cross.
Mr. Pettis, can you hear me?
Yes, sir.
Okay. If at any time you see my lips moving, but you can't hear me, let me know, please, okay?
I can't see, though. I can only see the judge and my own picture on this conference.
Okay.
But
Mr.
I can hear you. Go right ahead, sir.
Okay, Mr. Pettis, Plaintiff's Exhibit 3, on top it says Uber Transport, is that correct?
Yes.
So this is Uber Transport's bookkeeping, is that correct?
It's from my bank account. Yes, sir.
Okay, but it says Uber Transport, so it's a different company, correct?
Yes, it's not the same as Litamosa. It's a different company.
Different company, correct?
Yes.
And in your petition, well, let me ask you this. Do you know the Secretary of State, when did you become an owner of Uber Transport?
An owner, that company started, I guess, in
In relevance,
2014 or 2015.
Relevance,
I'm gonna allow it,
He opened the door, Judge.
yes. I'm
that's
gonna
fine. He said 2014, 2015. Go ahead.
Allow it. You can answer the question.
Do you know the Secretary of State has the business organization information, the filing history, and you're not listed as a director of Uber Transport Company, Inc.?
No, I'm not.
Objection,
I'm not
relevance,
list.
relevance, objection. When I make an objection, please let the judge rule, James.
Yes, overruled.
What relevance does that have to this, Judge? Okay.
Hold on.
All right, go ahead.
Some leeway, like I gave you some leeway.
Best evidence, Your Honor, best evidence, I object. If he can pull it up, is it an exhibit?
Allow Mr. Tames to ask his questions. I need you to be quiet. Go ahead, Mr. Tames.
So, Mr. Pettis, would you be surprised to know the Secretary of State in the original filings of Uber Transport Company, Inc. does not have you as a director of the company?
It does
Objection,
not
court.
have me as the director.
I'm sorry?
I am not one of the directors. I am the owner. There's a difference.
Thank
And
you.
do you have any documentation, written documentation that says you're the owner of Uber Transport Company, Inc.?
I'm sure if I look for it with my accountant, they can get me all the paper documentation I need.
Okay. And you represent to the court then that the plaintiff's exhibit 3 is only limited to Uber Transport Company, Inc. Is that correct?
I don't understand the question. I thought that if I understand that spreadsheet has Uber, my personal account, and my Discover card, all the expenses I paid out of those three things.
Okay, so you're mixing in plaintiff's exhibit 3, your personal credit card information, your personal checking account information, and then information regarding Uber Transport Company, Inc. Is that correct?
I'm not mixing it up. If you actually look at the spreadsheets, they're separate spreadsheets. There's one for Uber, one for my personal account, and one for my Discover card. And like I said, then we did 3 separate ones, and then we did one master one that had all the expenses I paid together. But if you need me to separate them between each entity, I can easily do that. I have that right there.
Mr. Pettis, you testified for about 10 minutes about plaintiff's exhibit 3, and plaintiff exhibit 3 only lists in all of its pages Uber Transport on top.
Well, then maybe it's missing the amounts that I put in from my personal account. Maybe that's just the amount from Uber, not the amount from my personal and my Discover. Maybe it's higher. I would have to look at the receipt. It's probably a higher amount than if that you're saying that's only Uber, then there should be one with James Perez and one with Discover Card that adds to that amount.
Mhm.
I mean, I can prove it all. I have receipts, documentation. I have everything. I have QuickBooks. I have everything in files ready to go.
Yeah, but
I
point
can't hear
is
you,
the plaintiff's exhibit 3 does not say Litamosa. Is that correct?
I don't see it there. No, it does not.
And by your own admission, you're agreeing that you tend to mix personal credit card, banking, and business information in spreadsheets. Is that correct?
No,
Okay.
Objection
I
form,
explained it.
relevance, Judge.
It's fair game, Mr. Knudsen. I'll allow it.
I mean, I'm telling you the truth. I got nothing to hide. You all want to see the documentation? I got it right there. I mean, I ain't perjuring myself. I'm telling 100% the truth.
Wait for the question, Mr. Perez.
I'm sorry.
Mr. Perez, your petition says that you are a joint and equal shareholder of Litamosa. Is that correct?
Yes, by verbal agreement.
And you don't have any shareholder certificates to prove that. Is that correct?
No, I don't, but I got emails and I got text messages that prove when we discussed it.
Did you bring those today?
No, I don't, because
Yep.
nobody asked me for them.
And
Sorry.
that is, you realize that today the determination is whether or not you have any authority to act on behalf of Litamosa, correct?
I did not understand it. That's exactly what it was. I thought we were gonna get information about what they did and bank accounts and all that. I'm sorry, but no, I did not understand it the way it was supposed to be.
And you don't have a corporate agreement that makes you a joint and equal shareholder. Is that correct? A written
Objection.
corporate agreement. Is
No,
that correct?
no, I do not.
Okay. When did you and Mr. and Mrs. Cerda agree that you would be a joint 50-50 owner of Litamosa?
When we started with the Penske trucks. Before that, we had the Ford truck, and that was divided 2 trucks and 2 trucks.
Okay. When did you when, in your opinion, did you start, quote unquote, with the Penske trucks? What date?
That was, can't give you an exact date, but it was probably the summer of last year, maybe April, March of last year.
Summer or April of 2020?
Yes, because I
In
remember
April,
that
March Here.
when Litamosa filed the paperwork for the corporation, they were having a bunch of problems with the corporation and actually getting their MC.
Object to
So
Can he finish,
sorry.
Judge?
They-
Before he-
Sustain. Just answer the question, Mr. Perez.
Okay, so
Okay, so what?
prior to, it's your testimony, then prior to April or the summer of 2020, there was no agreement between you and Mr. and Mrs. Cerda to own Litamosa 50-50. Is that correct?
No, the agreement before that was, there was no Litamosa before that. The agreement before that, when they bought 2 trucks and I had 2 trucks, was we were running them and we were leasing them onto another company. We were leasing them to a company called STTS, but their trucks kept on breaking down. And then that's when we decided that we should not be leasing onto somebody else and we should open Litamosa so we could run the trucks ourselves and not depend on somebody else.
Right. So the question then is, yes, right, before the summer or April of 2020, there was no agreement between you and Mr. Cerda to operate Litamosa 50-50.
Objection.
Is that correct?
Objection, Your Honor.
I don't know. To tell you the truth, I don't know when exactly we made the agreement. It might have been earlier, but I'm not sure.
And so by your own admission, there's no definitiveness as to when this agreement was brokered, when it was supposed to start, correct?
Yes, it was supposed to start when we agreed to it in 2020.
But sir, you just testified that you weren't sure when it
Well,
started.
I'm not sure. You want me to give you
Putting
an
words
exact
in his-
date? I don't know it.
Okay.
I do not know the exact date.
Now, there is no written loan agreement or promissory note where Mr. and Mrs. Cerda or Litamosa were loaning you $141,425.60. Is that correct?
There is
Objection.
not.
What was the objection form?
Yeah, they didn't loan my client anything. My client loaned them.
We asked the question, Mr. Thomas.
Right, well, your petition says that you were loaned 141,425, or you loaned Litamos $141,425.60.
Exactly.
So
Correct.
you under oath, as Mr. Knotson pointed out, are telling the court that you loaned money, right?
I forget, well, loan it, yes, I was expecting it to be paid back. It wasn't a formal loan like you write it down with a bank or anything, but it was understood that if the money I was putting into the company was gonna be paid back to me first before any profits were divided 50-50. That was the agreement.
Yeah, and that's my point, correct? My question was that you do not have any written loan agreement or promissory note that encompasses that, correct?
Objection asked and answered, Judge. It's been answered like
Cleaning up, I'm cleaning up because we're getting,
Allow it.
confusing
Your
tests.
Honor, asked and answered.
It's allowed.
He said there was no written agreement.
When,
Okay.
I don't know
when
what else.
was the,
The
yeah,
courts have been made aware there's no written agreement.
when was the money borrowed?
It was over the span of over a year of me putting money into Litamosa. It started probably March or February of 2020 when I started paying insurance payments and stuff like that. And it had ended when they took over the company of March of 2021.
Okay. Was there supposed to be any interest paid on this note?
I did not ask for interest. I just wanted my money paid back for that I put in to start the company because that was the agreement. I wasn't going to charge them interest. I just wanted my money, my investment paid back first and then divide the profit 50-50.
Was the agreement that my clients had to approve and accept any of these expenses that you paid on behalf of Litamosa?
They were running the account. They knew everything.
We're getting into the
Yes.
detail.
Of course, that's
Relevant.
exactly what we need to do. We
But
need
yes,
to-
Objection, relevant, Judge,
Mr. Knotson overruled.
and he doesn't have to
Yes,
yell
but-
for the record.
I've been listening to
Yes.
council yell all afternoon, Judge.
Okay.
But yes, they did know. They did know, sir, because they were running the accounting after that, and they knew every time I put money in, I was telling Jimmy, "Hey, I paid the drivers through here. I paid this. I paid diesel with my credit card. I did this." So they knew all that.
Mr. Pettis, you just stop real quick.
What?
Mr.
All right.
Yes, you provided Mr. Knotson, you were handed copies of exhibits that the defendants submitted to the court. Are there going to be any objections to those exhibits?
That who submitted?
The defense.
Oh, the defense? Well, I mean, it depends if my exhibits are admitted.
Your exhibits were admitted.
Okay. And Your Honor, I mean, exhibit number 1, I don't know if that's a certified copy, but I mean, I would just,
It is a certified copy, Judge. It says on the first page.
yeah. I mean, I would just object on that basis. I wasn't made aware of this, and this proves our point of the fraud, based on my client's testimony. And, exhibit number 2 is, a company agreement. I would want to ask them who prepared this company agreement. It's not signed, so I object on that nature. It's blank, so there is no signed agreement. It's hearsay. It's not a valid agreement. It's not signed, so I object. It's not properly authenticated. So exhibit number 2, and then it shows Carmen Cerda 100%. So it's not properly executed. So I object to exhibit number 2. Exhibit number 4, let me see, that is IBC Bank. It was started January of 2020, Judge. I have no objection to that. That's looks like when it was started, the company. So no objection to exhibit number 4, which coincides with, that's when they started doing business. And, so I think that kind of puts the pieces of the puzzle together there, Judge, in my client's testimony. Exhibit number 6. I don't know what G&G, I don't know what this is. It's not a certified copy. I guess they're talking about the 2 trucks, but I don't think that that's relevant.
Is that the receipt for the purchase of the trucks?
Yes, sir.
Yeah, but it's not proved up in any form or fashion, wire transfers, and Judge, here, so I would object to 6. Number 7 is, I don't know what this is, electronic title copy. I don't know what this 4/30/2020. Let's
Hold on a
see.
second, Mr. Knudsen. Mr. Thomas, I think the rest of the exhibits basically just show
Ownership. That's correct.
and the court has enough. Mr. Knudsen, Mr. Perez, the Cerdas, the court's heard enough to make a decision on this court for today's hearing. Mr. Perez, and I want the Cerdas, both of you, normally I don't do this. You need to understand that today's hearing was not for the purposes of determining your causes of action. We are here on the injunction that was issued, temporary restraining order that was issued by the court, and whether or not it should be extended. Clearly, the plaintiff has failed to establish ownership in La Tamosa. So as to all aspects of the injunction or the TRO, they are going to be dissolved.
Your Honor, we would ask, I understand the court's ruling as to Lita Mosa, but we would ask for an injunction on their personal assets. I believe my clients established that monies were loaned to them. There was an agreement to pay them back. And
no, you did not establish that. And I will tell the parties this, there's some indication that Mr. Perez did put forth some sums. It's unclear what those sums were. And it's also unclear as to what was paid back or what had to be paid back. That's an issue that's going to be determined by the fact finders in this case. It's not for me to determine today. But the sole issue before the court today is whether or not the temporary restraining order is going to be extended, and it is not. That is not a comment on your claims against each other. The court also is finding specifically, just so I'm clear, the court is admitting exhibits 1. Was it 2? No, 3, 4, and 5.
1, 2, and 3 of plaintiffs and 4, 5.
No, your exhibits were admitted. Defendants exhibits 1, 4, 5. 3 is already admitted. You admitted it, Mr. Knudsen. 1, 4, and 5 were admitted. It's pretty clear that the world was on notice as of June of 2018 who the owners of this company was, Mr. Knudsen. And without anything more definitive from the plaintiff at this time, I don't see that the court in good conscience could extend the TRO. So the TRO is going to be dissolved in all aspects at this time.
And Judge, all I'm saying is, it's undisputed. They admitted that funds were placed into the company.
I'm not making a determination on that. It was clear to the court that some monies went back and forth.
All right.
But as your client testified, I don't have the receipts right now, but I can get them. It's not going to be sufficient for the court to make a determination on that right now, and I'm not going to. What I needed to hear was whether or not there was something more definitive that would have given your client authority to control the business actions of Latimosa, which it did not hear. So the court has ruled. And again, Mr. Perez, again, I'm not making a comment on whether or not you put money in or efforts into that and what you're entitled to receive. That will be determined as you go forward in this litigation. But for right now, this litigation is going to go forward without the TRO or an injunction. That's the court's rule.
All right.
And the court is.
And I'll call I'll call, because it's going to be very
discuss possible resolution to this. I
Yes.
think this is gonna come down to an accounting issue more than anything else.
It is.
And
And, you know, we're gonna be asking them to immediately return by tomorrow at 5, the $12,000, whatever the check was. If not, we'll
you
file
can
an
talk to them
appropriate
on the
report
phone.
with the police.
Judge.
Thank you,
that's
Mr.
all we have. Maybe excuse.
Court is adjourned.
Thank you, Judge.
Thank you, Mr. Clayton.
Thank you, Judge.
Thank you, everyone.
Have a great day, sir.
Okay,
Thank you
James,
very
I'll
much.
call you.